Welcome to Behind the Book, brought to you by the American Immigration Lawyers Association. This program takes you behind the scenes of AILA's best-selling publications. In this edition of Behind the Book, we discuss the nuances of the Child Status Protection Act with Charles Wheeler, author of AILA's Focus on the CSPA. For most practitioners, the CSPA is complicated and offers little guidance on how to decipher its inner workings. Join us as we go behind the book with well-known CSPA expert Charles Wheeler. Charles Wheeler is a senior attorney with the Catholic Legal Immigration Network, also known as Clinic. He directs Clinic's training and legal support section, providing training, technical support, legislative analysis, and legal reference materials. Charles Wheeler has specialized in immigration law and aliens' rights for 30 years. He is considered an expert on the Child Status Protection Act and has been invited to speak on the subject by both government and private entities. What is the Child Status Protection Act and what does it do?
Well, it was supposed to be a fairly straightforward law that preserved someone's age upon filing a petition or doing something else. So I think the intention of Congress was to allow children to stay children regardless of what happened during the administrative process. That was its goal, at least. Unfortunately, the statute was written so poorly to be almost unintelligible if you're trying just to read it and understand it from the statutory language. And we don't have any regulations. So what we're left with is about, I think, something like 15 memos from various agencies trying to interpret it, some of which actually contradict the other memo. So what we try to do in the book is condense all of these memos and all this information out there and try to make the statute intelligible and understandable to the average reader.
Why do immigration practitioners find this law so complicated?
I think a lot of practitioners get confused even with the basics of how you do this adjusted age formula. Some of them are a little nervous about using mathematics and figuring out age computation, looking back at old priority dates and trying to understand visa retrogression, things like that. So there's a lot of loopholes and areas that are still unknown as to how this is going to be worked out in practical terms.
What was the impetus for the CIS Ombudsman's teleconference on CSPA?
I think the Ombudsman Office wanted to do two things. They wanted to educate all of those people who tune into those on a regular basis, but they also wanted, I think, to get the USCIS involved more deeply in analyzing a lot of the gray areas and hopefully encouraging them to come up with final regulations, because that has spurred more questions and more interest and hopefully some more administrative action on this.
Why has the agency not promulgated CSPA regulations?
I think the agency is still trying to deal with some of these more problematic areas. One of the areas, for example, is this 1-year filing requirement. In order to meet the requirements of the CSPA and preserve your under 21 age, you do have to take some steps within that 1 year after the visa is current or available. And the agencies have narrowly defined this. For administrative convenience, they've defined it as the filing of certain forms, where the Board of Immigration Appeals is actually, with 3 unpublished decisions, broadened that much more to where it meets the definition of the statute, which is seeking permanent residency. So that's one of the things the agency is afraid of opening up the door too wide, and they're trying to grapple with internally how they deal with that issue. But there's also litigation out there on some of these key issues as well. One of the issues is what happens to derivative family members who age out. Do they get to retain that earlier priority date when the parent, who's now a permanent resident, refiles the petition, starts all over again? Statute seems to say, yes, they do. They get to retain that, while the agency takes a very more limited, narrow definition. And that, of course, is one of the raging issues in the federal courts. But there's other areas that are still gray areas that they haven't dealt with. And one of those deals when the petitioner, permanent resident alien, naturalizes. And the child, if they're under 21, becomes an immediate relative. But if they're over 21, biologically, but under 21 using their adjusted age, what happens to them? And right now, the word is that they move into the first preference category, which is a real deterrent, because if you're in the first preference category, you're backlogged, another 10 or 15 years, whereas if you'd held on to your 2A category, you'd be okay. So sending the wrong message out there to people who want to naturalize, and we've been vigilant in trying to inform practitioners on this issue as well. So I don't think the agency has that resolved as well.
Given your expertise on this matter, how close are we to seeing final CSPA regulations?
I think it's going to happen during the summer, but I don't know which summer it's going to be. So that's what I keep telling people. It's been, 8 years now, so I can't really predict when it's going to happen.
Can you explain why all immigration practitioners should have this book as a reference?
Well, they need to understand the basics of the Child Status Protection Act regardless of their area of practice, because it doesn't just affect family-based. It affects all derivatives in the employment-based categories. It also affects derivatives if you're doing asylum or refugee work or helping domestic violence victims. It impacts really almost all areas of immigration law. That's the way it's been defined and implemented.
What would you say to those practitioners who have not yet purchased this book?
I would tell them they can either read these 15 agency memos and try to make sense out of the statute, or they can get this book and read the first 2 chapters and get a pretty good idea of what's going on.